Okay, I'm live. I'm reading from Appellate practice. Looks like this. I don't even know the author. Regents of the University of California. Sounds familiar. 1966, so I'm hoping it's still relevant. The chief editor was Siegfried Hesse. Victor Chuan, Elaine Frank, Isidore Rosenblatt are the editors, and the consultant is Honorable Robert Kingsley. The preface begins as follows. Practicing before appellate tribunals has ordinarily been thought to fall within the traditional mainstream of legal activity. Certainly, most books written about the legal profession, at least for laymen, stress appellate advocacy and the judicial process. No doubt, to most observers, the flow of appeals does not appear diminished. Indeed, appellate congestion is ranked next to trial congestion as a cause of serious concern. However, the enrollment of 4,265 lawyers for the state bar's fall 1965 program on California civil appellate practice was considerably less than that mustered for previous major procedure programs of California continuing education of the bar. It makes one stop to ponder whether the practicing bar still regards appellate work as the main ingredient of everyday law practice. In fact, a profound apathy was noticeable among lawyers who attended. For the most part, they showed little interest in the subject, although the great majority reported on the questionnaire circulated after the program that it provided helpful information. A few observations may therefore be in order. While these are not based on exhaustive research or scientific survey, many are supported by the answers to the questionnaire. 1. Even though appellate courts are congested, the proportion of appeals taken from civil trial judgments has declined. For one thing, many more criminal cases are appealed today. For another, public question litigation occupies a much greater proportion of the time of appellate courts than it did 60 or 80 years ago. Commercial and business cases seem to have decreased. Perhaps an explanation for the apparent increase in appeals is that the total volume of litigation is much greater than formerly, and that while the proportion of appeals has declined, there are enough to give a superficial impression of an avalanche of appellate cases. 2. Of the total practicing bar, a smaller proportion of lawyers is engaged in civil appellate work than in past decades, when most lawyers viewed taking an appeal as part of the normal routine of handling a case. Moreover, many of those who take frequent appeals are older attorneys who represent clients for whom the amount of money in controversy justifies seeking reversal. A collateral consequence evident, particularly in the metropolitan areas, is a distinct evolution of a group of specialists to whom cases are referred because of their competence as appellate advocates. A similar sorting out takes place in the larger law offices, both public and private, where one or two people handle the appeals for the whole office. 3. The reason most frequently given for the declining proportion of civil appeals is the cost of a run-of-the-mill case. The next most common reason is the inconvenience of long delay between the perfection of an appeal and the appellate court's decision. Most are to some extent interrelated, because the client who can only finance a case thinly can neither afford additional counsel fees, transcript and printing costs, nor tolerate the lengthy period before the result is finally announced. 4. One frequent complaint is that the appellate process, as it now operates, favors affluent parties of large business enterprises who use an appeal as a tactical device to obtain a discount on the trial court judgment by forcing the winning party to settle at a lower figure in order to avoid the appeal. As put by an attorney, the appeal is a weapon in the hands of the losing side with money which, when used unscrupulously, effectively bars any recovery, just as though my client did not have a day in court. 5th, a possible cause of lessened interest in appeals is that eventual success is upsetting the lower court judgments occurs in only a minority of cases. Although reliable data are sparse, something like 65 to 80% of the cases are affirmed. Hence, the lesson that is learned is win below and do not count on the upper court reversing. In California, this tendency is accentuated by Article 4, Section 4.5 of the California Constitution, which requires the asserted error to constitute a miscarriage of justice before the appellate court reverses. So a miscarriage of justice, a term of art. Standard of review. Whether any of these observations has validity is besides the point. What does emerge is that the realities of appellate practice are far more removed from the generalities of most jurisprudential articles and books written about how appellate judges and courts function. The time has come to investigate yesterday's notions about the nature of the appellate process and explore its operations at the practitioner's level. For example, how many appeals are taken by lawyers in their careers? What are the factors that actually motivate the decision to appeal once the moment of anger over losing the case is gone? How much time is ordinarily spent in research and writing the brief? Does appellate argument have any impact when time is so sharply limited? What kind of fees are charged? Although appellate judges denounce the briefs that are filed as poor and the oral arguments to which they are subjected as mediocre, these standards may have little to do with lack of professional competence. They may be more directly related to the low fees paid for an appeal, which practically prohibit a lawyer from investing much time and effort. Appellate advocacy is underpaid in comparison to other legal work. There are many other questions to be asked, for no one really knows today what the facts are. If our legal system is to serve an exploding population and expanding society well and efficiently, the appellate process should be studied with the same intense scrutiny now being given to the trial courts. This new practice book does not strive to cope with these questions, being concerned with the technical aspects of appellate civil practice, but we hope that it will enable attorneys to make more efficient use of the time they do spend on appellate services. We are indebted to all chapter authors for their hard work and diligence in dealing with subjects that have received nominal attention in previous legal writing. Our gratitude is also due to the members of the Advisory Planning Committee for their guidance and enlightenment. In the appellate thicket, they were J. N. DeMayo of Santa Rosa, B. E. Wicken of San Francisco, Professor David E. Lewisell of the University of California School of Law in Berkeley, and Professor Ivo van Elstein of the University of California School of Law in Los Angeles. We must also set forth our appreciation for the advice given by Jeffrey C. Hazard Jr., now administrator of the American Bar Foundation, who was formerly a member of the faculty of the University of California School of Law in Berkeley. Particular debt is owed to Justice Robert Kingsley of the Second Appellate District and the District Court of Appeal in Los Angeles, who read the entire book in galley. He made many constructive suggestions, although he is not saddled with any editorial responsibility for the opinions or views expressed. The index was prepared by Dorothea A. Flaherty. Editorial production was handled by John Smale. Excellent assistance was received from Rachel Ellis in the earlier stages. Felix F. Stump, administrator. So, I'm going to see how long this table of contents is to get a feel for what we're going to be embarking on as we work through the book. Part 1, there'll be an introduction. Part 1 will be proceedings in trial court before appeal. Broken down into preliminary matters, attack on judgment in trial court, can the appeal be taken, should an appeal be taken, first steps in taking an appeal. And part 2 is proceedings in appellate court, including motions, new evidence and findings, briefs and oral argument, disposition of appeals, and proceedings after initial decision. And part 3, proceedings in trial court after appeal, problems and procedures after remand. Part 4 will include appeals from municipal and justice courts, appeals from inferior courts, and a table of statutes and rules. We'll begin on page 629, Rules and Amendments 645, and your index is 651. Might behoove us to start the next recording with the rules.